Hello, everyone. My name is Cheryl Thomas, and I am the Executive Director of Global Rights for Women in Minneapolis, Minnesota. And we are going to be talking today about how courts around the world and locally are adapting their responses to cases of violence against women during this pandemic of COVID-19. Global Rights for Women's mission is to work with partners both here locally and around the world on improving legal and systemic responses to violence against women. So we have used our experience that we have gained to adapt the programming to be relevant during the COVID-19 crisis. I am very happy today to be with Judge Elizabeth Cutter from Hennepin County here in Minnesota, and I will let Judge Cutter introduce herself.
Hi, my name is Elizabeth Cutter, and as Cheryl said, I am a judge in Hennepin County, currently assigned in our family court division. Before that, I was the presiding judge in probate, and before that, I was the assistant presiding judge in criminal. I've worked with Cheryl for many years, and I've been involved in different areas of violence against women my entire career, both as a judge and as a prosecutor.
And you have actually done training on the court's response to violence against women in many countries too. Is that correct, Judge? Yeah.
That's right. With you, as a matter of fact.
Yes, exactly. So for those unfamiliar with Hennepin County in Minnesota, could you just kind of give us a picture of where you sit in our legal system here?
All right. So Hennepin County is the largest county in the state of Minnesota. It is the 4th judicial district out of 10 judicial districts in Minnesota. We have a population of about 1.2, little over 1.2 million people in the county. The county seat is Minneapolis, which is the largest city in the state. However, Hennepin County has some large rural areas as too when you get farther west of Minneapolis. So it is both an urban, suburban, or all urban, suburban, and rural county.
Right. Those dynamics with cases of violence against women in rural areas can have some just really different components to them, can't they?
Yep.
Yeah, just the access to remedies and services and all of that. So maybe you can tell us, now you are in family court right now, so that's civil court. And of course we have our criminal court. What services are normally available? Let's just talk about our civil court, our family court for domestic violence victims there.
Well, we have orders for protection. Those are issued out of family court. Any hearings involving orders for protection are held in family court. Permeating throughout family court, with the kinds of things that we handle are orders for protection, divorce or dissolution, parenting and custody questions, and throughout all of those, by statute and also by practice in Hennepin County, is an examination of whether there is domestic violence in the home or between the parties involved. And that by statute is one of the factors that we take into account in determining what arrangement of custody and parenting is in the child's best interest. So domestic violence is a paramount concern in family court in all of our case types.
Okay, and that would be including orders for protection too?
Yes, yep, we do have orders for protection. 4 days a week. We divide there are 2 different calendars. One calendar is for couples who have children in common, and another calendar is for those who do not.
Excellent. Okay, thank you. And now we were talking, just to clarify, about how the procedures are generally in Hennepin County and family court with orders for protection. And you described earlier to me pretty eloquently how important you think the civil order for protection remedy is, generally speaking. And then we started talking, which we will do here, more about how that certainly is the case during these times of isolation during COVID. Can you just generally talk to our registrants, our participants here in this interview, who are watching this interview, that your sense of the importance of orders for protection in domestic violence cases?
Well, I think that in the reason I wanted to go to family court after I finished my term in probate court was because of the response that our family court has had to violence against women in intimate partner violence. It's in my view, particularly after all of my years in criminal, a effective response because it's immediate. When a petitioner files a petition for an order for protection, included with that is an affidavit of why that order is needed. The judicial officer whose job it is to do the signing the day that that petition is filed has 60 minutes. So that request for a protective order is reviewed within 60 minutes of filing, and a determination is made. Part of that protective order is the ability to address the other areas that are needed: child support, spousal maintenance, housing, and of course the stay away, which is the protective order. It also prohibits a respondent from possessing firearms. So it's an immediate response to an allegation of domestic violence. In criminal court, it would, because for good reasons, that immediate response isn't available. But it is in family court. And it's also a victim controlled process, which is important too.
Right. And why is that important?
Well, because when you look at the nature of domestic violence and the loss of power and control that a victim has, this gives that back to that victim survivor. So I can control the contact that my abuser has with me.
Okay, wonderful. Now, you obviously have had to go through many changes in court practices and policies since our state in Minnesota has been under a stay-at-home order. And will you talk about kind of the leadership that you have seen from our state and our Supreme Court that gives you direction in how to make sure that these remedies are still available to victims of violence?
Well, starting with our governor. Governor Tim Walz. He issued a peacetime emergency on March 13th, and restricting public gatherings and public activities for health and safety reasons. And I have been so impressed with his concern, not only for the health of the citizens of Minnesota, but safety. And he has underscored in his presentations on his peacetime emergency the need for people who are not safe in their own homes to have the ability to seek relief. That same concern comes through our court leadership, Chief Justice Lori Gilday, and in Hennepin County, our Chief Judge, Ivy Bernardson, and all of the leadership on the Hennepin County bench. The primary concern that all of these leaders have expressed is for the safety of the citizens of Minnesota. And Justice Gilday's recommendations and guidelines for domestic violence and orders for protection underscore that the significance of personal safety. So we are in Hennepin County so appreciative for the leadership that we get at the state level, but also at the local level. And our own presiding judge, Margaret Daly, it carries that through too.
So these leaders have actually, well, starting with the governor's order and then the the response of our Supreme Court, these leaders have actually mentioned cases of violence?
They have. Yep.
Okay.
And that, of course, has been a primary concern in family court because that is what we do.
And they elevate those cases to
yes.
make sure that okay,
they are Justice Gilday created a graph of case priority, and I think it's called super critical. The orders for protection are in that super critical.
Super critical. Okay.
So I think that should be heartwarming to those of us who have been involved in this movement for as long as we have, to have the orders for protection given that kind of attention.
Okay, that's very helpful. Now, it is the case, because of the stay-at-home order, that we can't have hearings like we used to, in-person hearings I'm talking about. So talk about that and how you, as a judge who is issuing, who has a responsibility to issue both emergency and longer-term orders, how that's working when you can't be in the courtroom in person with seeing the victim, seeing the offender. What are you doing to adapt to that?
Well, I'm pulling up my forms. So the way that the order for protection process works is a petitioner will file a petition requesting a protective order. That is either granted or not granted within, our goal is within 1 hour of filing. If the only request is a stay away from my home, stay away from my work, or other location where you tend to be, then no hearing is required. And I'm talking pre-COVID.
Right, by our law.
By our statute. A respondent is personally served with a copy of that petition as soon as possible. Once the respondent is served, the respondent has 5 days to request a hearing. A respondent can ask for an exception to that 5-day period, and there are times when those are granted, but in general, 5 days. If that's one way a hearing would be held. The second way is if different relief is requested. So if temporary custody of joint children is requested, child support, maintenance, what are the other? Restitution, treatment, so chemical dependency or batterers treatment, or 50-year order for protection.
Okay.
So those are of personal property, the use or possession of personal property that is shared. That will be a reason for, what is another one? Restraining the respondent from disposing of or destroying personal property. So the use, possession of personal property, restraining destruction or disposition of personal property, those are items that would normally trigger the need for a hearing. Now with COVID, they don't, unless, as Justice Gilday indicated in our Chief Justice said, if the relief requested presents an immediate liberty concern or raises public or personal safety concerns, then a hearing would be held. So if joint parents, if a parent is being denied access to or custody of or parenting time with joint children, then a hearing may happen. If the other is if the respondent is being removed from a shared home, then a hearing would be triggered as well.
Okay.
And then we also had to redo our forms to make sure that we got the information that we needed to make the determination of whether a significant liberty interest or personal safety risk was presented.
Okay, got that. So pre-COVID, now, or in regular times, I should say normal times, if a respondent to the applicant's order for protection didn't request a hearing at all, then our emergency order under our law just stays in effect. Can you just describe that?
If the petitioner only asks for a stay away and the respondent does not request a hearing, then that order becomes a permanent order and it will be in effect for a 2-year period.
Okay, yeah. So there's no hearing there anyway. So well, what you've just said is the adaptation of that during COVID, where if there's this safety issue at stake or custody issue at stake, then the hearing will proceed.
And if other relief is requested that doesn't raise those concerns, then we notify the parties, we're not going to have a hearing now.
That's what I was getting at. Thank you.
Yep. But we will have one if you request it when the COVID emergency is over.
I see.
And here's how you will know. Here's how you'll know that it's over. And we have a link to the COVID updates. And we also include a form for them to use to request that hearing that says, I wanted a hearing. I mean, oftentimes, so a petitioner may ask that for restitution. I have medical expenses that I think the respondent should pay. Or the respondent broke my car window. The respondent should pay for my car window. But as time goes on, the petitioner may say, I don't care. Or I want the respondent to have chemical dependency treatment. And in the meantime, the respondent went to treatment or stopped drinking or whatever it was. Well, I no longer want that relief. And that has happened even before COVID, that by the time we get to the hearing, even though they're fairly quick, the petitioner says, well, I'm not interested in that relief anymore. So what we determined is that we don't want to schedule a lot of hearings that aren't going to happen. So we informed them of the process that they should follow in order to demand that hearing that will still be available for them. And the same, that's for petitioners or respondents.
Okay. So you described how you have a fair amount of discretion in under this Supreme Court order about what are issues that really raise the safety that's been prioritized by the Supreme Court. Could you talk about that just a little bit?
Well, we've identified those that we know we're going to see. And we have another category on the respondent's request for a hearing. So in case there's something we hadn't thought of. So we have the new form, and let me bring that up. The new form for a respondent to complete in requesting a hearing won't come up. Here it is. Okay.
Technology.
It acknowledges when the person was served, and it says that that they order removed the respondent from a residence shared with the petitioner, or denies custody or parenting time to children who earlier court order had granted him parenting or custody, or that they were married and now they don't have. So you can have unmarried people who have a parenting custody order. You can have married people who presumably joint children, they have equal parenting and custody. And then there's an other category. So there may be something that a circumstance that fits Justice Gilday's requirement of a paramount liberty interest or a paramount safety interest that we didn't contemplate or doesn't neatly fit into the categories we've looked at.
Good. That gives you some discretion for cases that you just don't anticipate.
Right.
Right. So you also
I think that we talked before this about the race to the courthouse, and that is not uncommon, that the true or the predominant aggressor is the one who gets to the courthouse to request an order for protection first, and the responsive or non-aggressor, the victim survivor, requests an order for protection later. That might be a good other category.
I see. Okay, so there's mechanisms for you to make sure that you're getting the relief to the person who needs it the most.
Right. And I think that, I mean, the overarching guidelines are safety. How do we keep people safe? What is the best mechanism for ensuring the safety?
You mentioned, Judge Cutter, that you've seen a decrease in applications for orders for protection, both emergency and longer term. Can you describe why you think that is and your concerns about that?
Well, it is a concern because I think that the order for protection process is our most effective way of providing relief and protection to victims of intimate partner violence. I think that because of the way that we need to file the orders and the petitions for orders now, it's more challenging, it's more difficult. You can do it online, but you've got to have free access to a computer.
Right.
And if you're living with the abuser, that access might be compromised. There was an article in the paper, and I think I have it here, that is substantial the number of the police calls since COVID.
Right. 2/3, I think it was.
Yeah, 2/3 of police calls are related to domestic violence. That does not surprise me. And from the advocates I've talked to, they all believe that the incidence of domestic violence will increase. I mean, we see an increase at holiday time when people are together, times of economic stress, times of uncertainty, and this is all of those.
And this is what we're hearing from our colleagues from all over the world, is that the incidence of violence has gone way up with intimate partner violence.
Well, and not only is that a risk for the victims of intimate partner violence, but also on multiple levels for law enforcement responding to that.
Right, exactly.
And then for incarceration, because we do have a mandatory arrest policy. And so we're incarcerating people into a system that also could jeopardize health. And that too could be a barrier to calling.
Right, exactly. Explain that.
I mean, are you going to take in a relative you haven't seen for a few years and you don't know where that person has been, and you've got somebody vulnerable living in your house, or you may be vulnerable? So as the victim of intimate partner violence, do I want to call the police and get this person kicked out? Do I want to get an order for protection when I know this person has nowhere else to go? So I think that there's the practical barrier that it's more difficult. Right. The Domestic Abuse Service Center is Hennepin County's one-stop shop for victims of intimate partner violence. You can file an order for protection. You can meet with an advocate. You can meet with law enforcement. So you can get a police report filed. You can meet with a prosecutor. All of that is available to you at the Domestic Abuse Service Center. Now that is still open, but people are working remotely.
And how does that concern you? you care about seeing advocacy services for victims in even making sure their application is complete.
Yeah.
Can you talk about that just a little bit?
Well, when we have petitions that are filed without the assistance of advocacy services, we might not get the information that really shows us what the threat of harm is. So there may be conclusory statements that don't tell us what we need to know to make a good determination of whether an imminent threat exists.
Right. So with the advocate there in person working with a victim of domestic violence, that person has the professional expertise to make sure what's down on that application, what's put down on the application is complete so that you can know the real situation. Sometimes that just doesn't happen now, I assume.
And I think that the advocates are available remotely, but that's another hurdle.
Exactly. Then
so
you have to,
it isn't that
find
they aren't
available to the computer
or a phone. And it's not that they can't do as good a job remotely, but it's just one more thing you have to do to get that help.
Right, exactly. Okay, so maybe we can I so appreciate your time, Judge Cutter. I'm wondering if you have anything else you would like to point out as what you think might be a promising practice that others can take from, or a concern that you want to alert folks to as the courts are responding.
Well, one of the things that you and I talked about briefly before we started recording was the importance of having because an order for protection is victim driven, petition victim survivor, that the petitioner is the one who requests the order, and the petitioner is also allowed to request a modification or vacation cancellation of the order. Before COVID, those hearings required, in Hennepin County, we always required the petitioner to come to court. The statute requires that we confirm the identity. And I have found in my own practice that listening to the reasons that in ensuring that it isn't that the petitioner isn't being coerced or forced into making the request, but also saying, do you know that you have an alternative? You can allow contact, but abuse only would be prohibited. That way the order stays in effect, but the respondent is prohibited from abusing physical abuse or the threat of physical abuse. And I would say, I'm giving this anecdotally because I can't give you a hard number, but not infrequently the victims say, "Oh, I didn't consider that. That's what I want." Or if I cancel the order, which I will do, that means that the treatment that was ordered also is no longer required. And less frequently, the petitioner will say, "Oh, then I don't want to cancel the order." So I think it's important to still have those hearings and to make sure that this is what the petitioner wants, and that alternatives have been discussed. There have been times too when the petitioner comes with an advocate, and I'll make a proposal and the petitioner isn't certain, and then we'll take a break for the petitioner to spend time with the advocate to talk about what is the best thing for me to do. So,
and that can't happen. The advocate can't. Now, is there a way that
we could do it remotely?
Okay.
But it is, it's just, as we know, those hurdles make life hard.
And when you're in an abusive situation at home, to be on a computer is very, very difficult, right? Or even a phone.
I mean, our goal has always been to make this process as fast and as user-friendly as we can. And COVID makes it not as easy. I think it can work, and I think it is working. And we just need to always review what we're doing, and is this the most effective way, and is there other technology that we can use to make it more effective?
So if there is a communication from the survivor that she wants to drop or end the order, tell me again what happens. There's just really.
So what happens now is if
during COVID, yeah.
Yep. A request will require a hearing.
Okay, because that falls under that safety. Excellent.
Yep.
Okay, good. And that's
because sometimes leaving that order in place is a more dangerous position for the survivor.
Sure.
You and I have talked about this a lot, that the victims of intimate partner violence may to the outsider be acting counterintuitively, but we can be confident that the decisions that they're making and the actions that they're taking are to make themselves safe. And so we need to go ahead.
Well, just another thing to point out, your insight into making sure that the victim knows, even she could keep a stay away order in place.
Yep.
The beauty of a law like Minnesota's and many other places that criminalizes the violation for the order is that holds then that kind of motivation over a abuser not to abuse if you've got that order in place, because he can be arrested for that then.
And I think, as you and I have talked over the years, one of the most important features that our system has is to be able to be a door for a victim survivor of intimate partner violence. And so one of the opportunities that we have as judicial officers is at that hearing, when the petitioner is requesting a modification or cancellation of an order, to encourage the petitioner to come back if needed. I am going to grant this, and I'm granting it because I believe that you know your safety risks better than I do. But I want you to know that our door is open for you to come back.
Such an important message. Such an important message that judges have the power to say.
And I've heard from advocates too that a lot of victims want to have orders canceled, but they're afraid of how that will be responded to by the system. And so what we in Hennepin County try to do is to make sure that they know we're here to keep you safe. It's it's not our order.
You. not about pleasing you. And that when she needs you, that's what these are for.
And I think Hennepin does a really good job of that.
Well, Judge Cutter, thank you so much for this interview and your time. I know how busy you all are in adapting these court processes and policies to this incredible situation that we're in. So thank you for your work and your insights today.
Well, and we look forward to suggestions from the community too, to how can we improve our response. And it's ever changing.
I was going to mention, one of the first things you did the first week in our stay-at-home order from the governor, I remember hearing from our staff attorney that you were right down there meeting with our Minnesota Coalition for Battered Women, now called Violence Free Minnesota, hearing from those advocates. What were their concerns? And that is just a really outreach that I think is just so important, to be right in touch with those advocates who are on the front lines with victims. And thank you for that.
Well, and I would say too that any system response has got to have the input of victim survivors and advocates. How do we do this best?
Like this, where nobody has ever been through it before. So Thank you for that. So important to hear that input from people in power in the justice system like yourself.
Well, thank you.
Thank you very much.
Good to see you.
Yes, nice to see you too. Take care.
Bye-bye. Wash your hands.
Wash your hands, everybody. Yes.
All right. Bye-bye.
Bye-bye.